script to adjust. Ever wonder if you actually have any legal right to stop that? Today, I'll explain sunlight and property law like you're 5 years old. By the end, you'll know exactly what rights you have. You'll also learn what your neighbor might have already violated, and what to do before your options disappear forever. Quick note, this is legal education, not legal advice. Laws vary by state, so check your local rules or talk to a property attorney in your area. Here's the situation. You bought your house and you loved the light. Morning sun in the kitchen, afternoon warmth in the living room. It was part of the reason you bought the place, so this really stings. Then your neighbor, let's call him Dave, decides to add a second story. Maybe it's a bedroom or a home office. Whatever it is, it goes up fast. Suddenly your yard looks like the bottom of a canyon. Your plants are dying, your solar panels aren't working right, and your house literally feels smaller. You call the city, and they tell you the permits were approved. You call a lawyer, and that's when you hear the sentence that changes everything. States, there is no legal right to light. In England, there's something called the right to light. If natural light has been reaching your windows for 20 years without interruption, that right gets legally protected. You can actually stop your neighbor from blocking it. The English figured this out in 1832 with something called the Prescription Act, and it's still used in courts today. English courts have awarded damages and even ordered structures to be partially demolished because of this doctrine. It has real teeth, and it gets used. The United States looked at that concept, shrugged, and mostly passed. American property law is obsessed with the idea that you can do what you want with your own land, as long as you follow local zoning rules. And zoning rules care about setbacks, about height limits, about safety codes. They do not generally care about your sunlight, so Dave can build up, build wide, and as long as he got his permits, Dave is probably completely in the clear. That's the counterintuitive punch in the face this topic delivers. You can lose something you've counted on for 20 years, something that was literally part of why you bought your home. And the law calls it completely fine. That sounds fair, right? It isn't. And here's where it gets interesting, because this is the part Dave hopes you never find out. There is one doctrine that can change everything. It's called a solar easement, and in several states, it can actually protect your right to sunlight. An easement is basically a legal agreement that gives you a specific right over someone else's property. A solar easement says your neighbor cannot block your light beyond a certain point. Here's the catch. In most states, solar easements don't happen automatically. You have to create one. You have to negotiate it, put it in writing, and get it recorded with your county. Think of it like a reservation at a restaurant. The table exists, but nobody's holding it for you, unless you call the head. If you never called, someone else gets the table. Some states make this easier than others. California has solar easement statutes, and Colorado does too. Florida, Wisconsin, and a handful of others have actual processes to help you lock in your sunlight rights. In states with these statutes, the easement gets recorded with the deed, which means it travels with the property even when ownership changes hands. But if you're in a state that doesn't have this framework, your options get narrower fast. Now here's something Dave definitely didn't mention when his crew showed up. There's a second way to protect your light, and it doesn't require your neighbor's cooperation at all. But it only works if something specific is already true about your situation. Dave didn't wake up one morning and decide to legally ruin your life. Dave just wanted a bigger house. But here's what Dave's team actually did. Dave's contractor didn't knock on your door. Dave's architect didn't ask how your vegetable garden was doing. And the permit office approved the plans based on setbacks and height limits, not based on what your backyard looks like at 2 p.m. on a Tuesday. Nobody in that chain was thinking about you. The system assumes you'll protect your own interests, which means you have to. Here's the second protection, and this one is the plot twist. In some states, if you've been receiving unobstructed light through a specific window for long enough, you may have already earned a legal right to keep it. It's called a prescriptive easement. It works like adverse possession, the same doctrine that lets someone claim your land just by using it long enough. You don't negotiate it, you don't file for it, you acquire it by the passage of time. In some jurisdictions, 20 years of uninterrupted light through a specific opening creates a legally enforceable right, a right your neighbor cannot simply build over. It's like squatters' rights, but for sunlight. Completely legal. Also completely weird. Also potentially your strongest card. Here's the brutal catch. Prescriptive easements for light are not widely recognized in the US. California courts have largely rejected them. Many states have never ruled on them at all, and the states that might apply them want consistent, open, unchallenged use of that light for years, with zero permission granted. The second you ask Dave nicely to be careful with his addition, you may have just restarted the clock. That one polite conversation could erase 20 years of legal standing. It doesn't matter how casually you said it, or that you were just being a good neighbor. Nobody tells you that part. So where does that leave you? Your living room is dark. You've looked into solar easements, never created one. Prescriptive easement, uncertain, depends heavily on your state. The city approved his permits. Here's what you actually do, and step 1 takes less than 10 minutes. Check your deed and your neighbor's deed. Sometimes solar easements were created by a developer years ago and recorded with the property. They exist and nobody's using them because nobody knows they're there. This is more common in planned communities and newer subdivisions where developers anticipated density. One call to a title company or a quick search at your county recorder's office can tell you in an afternoon. Check your local zoning code specifically. Not just whether his addition was permitted, but whether height limits and setback requirements were actually followed to the inch. Contractors make mistakes, and permits get approved on plans that don't match what actually gets built. Inspectors don't catch everything, and discrepancies between the approved drawings and the finished structure happen more often than most people realize. One violation on Dave's side and you have real leverage. If your sunlight powers solar panels, you may have a stronger case than average. Several states have specific solar access laws that protect active solar energy systems. Not just general sunlight, but specifically the ability of your panels to function. With energy costs rising and more homeowners investing thousands of dollars in solar installations, these protections are becoming increasingly relevant. The average residential solar installation costs between $15,000 and $30,000. That's not a lifestyle choice. That's a capital investment the law is starting to take seriously. Your energy bill is a legal argument, and most people never realize that. And talk to a property attorney before you do anything else. Not to sue Dave, just to find out what your state actually says, and whether the prescriptive easement argument has any teeth where you live. Some attorneys offer free consultations. One call to tell you whether you have a real case, or whether your energy is better spent buying better curtains. Here's what you actually learned today. Solar easements are real, but you have to create them before construction starts. Prescriptive rights exist in some states and can be erased by a single friendly conversation. Solar access laws may protect your panels specifically, and zoning violations are worth checking because contractors make mistakes, and those mistakes become your leverage. The people who find these doors are the ones who went looking. Dave's addition is up. The question is whether you're going to look. Drop a comment. Do you think the US should adopt a right to light the way England did? Or does property owners' freedom to build matter more? If you enjoyed the video, make sure to like and subscribe, and make sure to leave a comment on what topic you'd like to see next. Thanks for watching.